I'd like to welcome everybody today to our press conference. This is a simple conversation about the basic preservation of rights of Georgians. Every Georgian should be free to worship and exercise their faith without unfair federal, state, or local government intrusion. The bill that we're talking about today, the Georgia Religious Freedom Restoration Act, protects ordinary people from unfair state and local government intrusion by exactly mirroring the bipartisan federal religious freedom restoration law that protects people today from unfair federal government intrusion. After the federal RFRA law was passed almost unanimously in 1993, the U.S. Supreme Court ruled that the federal RFRA only protected people from unfair federal government intrusion and would not protect people from unfair state or local government intrusion on their religious rights. Since then, 34 of the 50 states have adopted their own state RFRA laws or seen the courts in their states adopt RFRA protections by judicial ruling to protect people from the overreach of state and local governments. In 1998, Senator Barack Obama, then a state senator, voted for the Illinois State Religious Freedom Restoration Act statute. In Georgia in 2016, Georgia passed a state bill that included language dramatically different than the federal RFRA language and was subsequently vetoed by Governor Nathan Deal. In 2017, in a religious rights case on one of our campuses, there was a student talking in a free speech zone, and the case that came from that circumstance, our Attorney General confirmed that without a state RFRA law, Georgians do not have true religious freedom protections, allowing state and local governments to infringe upon people's faith for only a rational basis test. In 2021, Montana and South Dakota became the 33rd and 34th states to adopt a state RFRA law, and they did that by adopting laws that closely mirrored the federal RFRA language. RFRA, or the Religious Freedom Restoration Act, puts the First Amendment right of free speech, freedom of assembly, and freedom of press on par with the freedom of exercise of one's religious faith, by creating a balancing test to weigh a person's right to practice their faith and balancing that with the government's power to limit their actions. Under RFRA, before the government can force a person to violate their faith, it must first show that there is a compelling governmental interest and that the government is accomplishing its goal in the least restrictive means possible. This balancing test, which is referred to as strict scrutiny, is the balancing test that's applied to all constitutional rights. But because of the courts, the United States Supreme Court's ruling in 1997 saying that the federal statute could only apply to federal government agencies, our state is left with the question of, will we mirror the federal protections to apply to state and local governments for our citizens in Georgia? Courts further then held that a government could not force, as an example, the examples of RFRA in real life are examples in which the government was shown that they could not force the Mennonite owners of a Pennsylvania wood products manufacturing company to purchase and provide abortion-inducing drugs and devices for their employees. The Religious Freedom Restoration Act, in another circumstance at the state level, protected Philemon Homes, which was a faith-based halfway house for transitioning prisoners. They were allowed to continue offering its ministry after the local city council changed the zoning law to attempt to shut down Philemon Homes. The Religious Freedom Restoration Act in that state protected Philemon Homes being able to continue to exercise their faith in practice in their community. Good Samaritan Arnold Abbott in Florida was arrested for serving meals to homeless people in a public park. The Florida State RFRA ultimately acquitted him of all charges and led to the city changing their ordinance to accommodate the feeding of homeless folks in a public park by Mr. Abbott and folks who shared his religious beliefs. Likewise, a devout Sikh and decorated Army captain was allowed to serve his country while wearing his articles of faith every day and going about his duties, which is uncut hair, a beard, and a turban. The Religious Freedom Restoration Act does not determine court outcomes, but rather ensures that people get a fair day in court when state and local government actions impact their faith. That's what RFRA is about. RFRA is a balancing test. It doesn't predetermine any outcome, but takes the difficult circumstances we find ourselves in, where different interests are clashing against each other, and weighs them and balances them fairly and appropriately in a way that's been tested for decades and has shown time again that this careful balancing test allows the fitting together of otherwise conflicting interests in a fair and balanced and legally defensible way. That's what RFRA's intended to do, and that's why in filing the Senate Bill 180, the Georgia Religious Freedom Restoration Act, we're ensuring that the language of Senate Bill 180 mirrors exactly the operative language of the Federal Religious Freedom Restoration Act statute. There's no additions for one side or the other. It's simply a question of mirroring the same protections that citizens enjoy from federal government intrusion and applying those same protections to potential intrusion from state and local government. With that, we'd like to read a section of the bill that talks about just the legislative findings, then we'll get into some specifics. Whereas the framers of the United States Constitution and the people of this state, recognizing free exercise of religion as an inalienable right, secured its protection in the First Amendment to the United States Constitution and in paragraphs 3 and 4 of Section 1 of the Constitution of this state. Whereas the Supreme Court case, the City of Bourne v. Flores, 1997, the Supreme Court held that the compelling interest test, which appropriately protected people from federal government intrusion through the 1993 Religious Freedom Restoration Act, to protect the inalienable constitutional right of free exercise of religion, must be adopted by a state through either legislative act or a court decision in order to apply to state and local government actions affecting one's exercise of religion. And then lastly, be it resolved, the General Assembly, in passing this bill, the General Assembly recognized that the language of the bill adopts the same compelling interest test provided for in the Federal Religious Freedom Restoration Act in a manner that applies it to the actions of state and local governments in Georgia using the exact same operative language of the federal statute. The reason this is important is, as we've talked about and alluded to here in the discussion earlier, is that although many statutes and many civil rights laws that we think about, from the Civil Rights Act of 1964 to the Voting Rights Act of 1965, apply both at the federal and state level. In this case, however, with respect to free exercise of religion, those basic constitutional rights that most Georgians believe they already have, they don't have. They're not able to enjoy it unless we, as a legislature, as directed by the United States Supreme Court, if we want to protect these rights and make sure they exist as most citizens think they have, we have to enact a statute to make that happen. What that looks like in practice here, if you can look to my right, I've got my right, your left. You can see a chart of First Amendment rights in Georgia and how they are recognized. What you see is the freedom of assembly, freedom of the press, which you all recognize and value, freedom of speech, and then the freedom of free exercise of religion. Without getting into a constitutional law class, first class, second class, and third class rights essentially represent the following. A first class right is something that gets what's called strict scrutiny level protection. Strict scrutiny, or the first class right, is something that's consistent with a fundamental constitutional right that we would enjoy through the Bill of Rights at the federal level or our state constitution at the state level. Intermediate scrutiny is, again, not to teach a law school class. This is consistent with a legal duty, something that's a creature of statute. If law says you have a duty to do A or B or C, or that's what's called intermediate scrutiny. And then third class right, what's called the rational basis test. As long as a statute applies equally to people and has some rational basis, then that's the level of protection you get. What does that mean? What that means here is that in Georgia, with respect to state and local governments, citizens have full constitutional protections in their freedom to peaceably assemble. The press has full constitutional protections for freedom of the press. And individuals engaging in speech have full constitutional protection from both state and local government for their free speech rights. But because we've not enacted a RFRA statute at the state level, the right of free exercise of religion, it has only rational basis level protections. Now, this was ruled on in the Azugnabaum v. Brzezinski case. It was a 2017 Georgia Gwinnett case. I'll get you the proper spelling for that. But in that case, there was a young man who was dutifully sharing the Christian gospel in a free speech zone. Now, this issue of free speech zones is a question in and of itself, but he was dutifully in the free speech zone as he was told to be. And he was shut down because the content of his words were deemed to be disturbing to other students. When he filed a claim on free exercise, and he filed a claim on speech. Those of you who followed this case, this was actually ruled on by the Supreme Court of the United States in a ruling that was announced in June of this year, the same week the Dobbs ruling was announced, but it ruled in his behalf on his free speech claim. What was not recognized by most, but is central to our discussion here, is in the pleading, our state attorney general in 2017, when he was addressing the speech question and the free exercise question, said the only protection he has for his free exercise is rational basis. As long as we're not treating him differently than other students, the school can essentially shut him down for any reason they want to, as long as there's a rational justification for it. For example, if a city wanted to put a parking ordinance in place, a city couldn't say, well, these citizens can park here and those citizens can't. That's not an equally applicable law. The city couldn't say, well, Fords can park here, but Chevys can't. That doesn't pass a rational basis test. There's no rationality to that. But above that level of equal applicability and basic rationality, any reason the city cites, they can shut somebody down if it has only rational basis protection. I use that as an example because rational basis really means anything that a state or local government would apply, they get. There is no level of constitutional protection at all. As long as there's a rational justification for something they're proposing to do, they get to do it. How that applied in the case of Georgia Gwinnett is, in essence, he had no right of free exercise that could influence the actions of the campus seeking to shut him down in a free speech zone. The only right he had, which he was able to take all the way to the United States Supreme Court, was his speech right. But his free exercise right was shown by an opinion of our state attorney general that just doesn't exist. Without state RFRA, you have the lowest level legal protection that exists in the whole realm of legal review for free exercise because we don't have a state RFRA law. What does that mean in another context? You can see here to my left. You can see the states around us. What we show here is everything in dark green has what's called strict scrutiny, first-class legal protection for the right of free exercise. Everything in light green is a third-class right, rational basis only. Okay? What that means here is the states around us, every citizen has full legal protection for their right of free exercise to practice their faith. But what are these dots in Georgia? You can see the entire state of Georgia is colored in light green because free exercise rights in Georgia are only a third-class right. They get that simple, that basic rational basis test, which in no way resembles what we would think about as a constitutional right. Any rational reason government would use to trample on their rights, government gets to, and there's no balancing test there at all. What you see, though, is these dots on the screen, or on the page, are military bases and state prisons. You see, because military installations are federal installations, if you're in a military installation, you get the same strict scrutiny level protection for your free exercise on every military base. And convicted felons in our state prison, these dots represent our state prisons. Even though they're state prisons, they're subject to the RLUIPA law, which is not RFRA. It's a separate law passed in 2000 that applies to institutionalized persons. And if you're in an institution like a state prison, you have full strict scrutiny protection of your free exercise rights. So the only citizens within the boundaries of Georgia that have full rights of free exercise are those that are on military bases and those are confined in prisons. You could make the case institutionalized persons in long-term care facilities. Our LUPA extends to some of them, but for simplicity of argument, to make the case very plain, it's troubling to lots of citizens that convicted felons in our state prisons have full rights of free exercise, but our law-abiding citizens do not. I think it's an important context for folks to realize. So as we address this, and as we take on Senate Bill 180, the intention is to do something that's very basic, very conventional, and should, as a matter of law, be non-controversial, adopting the same protections that we have at the federal level and applying them to state and local government. That's the intention of Senate Bill 180. That's all that it does. And by copying the exact language, this balancing test that reconciles these difficult circumstances where government interests come into conflict with a citizen's sincerely held religious belief, RFRA creates a balancing test to reconcile those in the most fair way possible. What RFRA does not do, does not guarantee a win for one side or the other. You know, what so many people want to propose in this discussion is exemptions. We need to guarantee these people this and guarantee those people that, and it becomes this dueling battle of exemptions. In fact, that's what happened, I think, sadly in 2016, when this issue was really last addressed by the legislature, is so many things were added to the bill that you had exemptions on this side and exemptions on that side. It became not just this balancing test that doesn't prejudge any case before it's considered, but it creates a measuring stick that can balance very difficult circumstances, and it travels across the state and is able to be contextualized in the local context in which it's intended. You know, folks have asked me the question about, you know, what about local governments? What impact does this have on them? You know, one of the questions that comes up all the time is the local public accommodation statutes. What is this going to mean for those? Folks said, you know, some communities have adopted public accommodation statutes that provide enhanced protections for people from the LGBT community because the local government has enacted that through local ordinance. I love the question. That's one of the strengths of RFRA. That's one of the things that's so strong about RFRA, is that RFRA is able to accommodate those different legal standards in local communities and bring them to bear in the conversation. For example, if you have a community that has an ordinance that protects and enhances the LGBT community's access to public accommodations, the first test in RFRA, the sort of this two-part test, is there a compelling governmental interest, and is the government's interest being implemented in the least restrictive means possible? If you have a community that has this enhanced protection for the LGBT community and public accommodations, the question of a compelling governmental interest is actually weighed differently in that community. It has more weight there than it does in a community that doesn't have that balancing test. So compelling governmental interest for that question exists in a community with that ordinance. It wouldn't exist somewhere else. Right? The localness of this, the RFRA doesn't prejudge anything. It's a balancing test that weighs the total of the compelling governmental interest in this circumstance, and then balances that against the free exercise rights of the individual, and ensures that if a compelling government interest exists, it's implemented in the least restrictive means possible, so that the religious the right of the individual could still be enjoyed in the most expansive means possible to still accomplish the compelling governmental interest. RFRA travels very well. That's what I said. RFRA is contextualized to local standards in ways that when we don't delve into the way it works, in the way it's intended, folks just simply don't understand. A corollary might be, this is not exactly how RFRA works, but a corollary would be, for example, in our state court system. You know, the burden of proof in a criminal case, for example. This is just by comparison. You know, the standard of proof in a criminal case is beyond a reasonable doubt. That standard might be applied a little differently in a court in DeKalb County or Fulton County or Dade County or Chatham County, but the standard stays the same. Even if finders of fact might weigh evidence a little bit differently, the standard is the same no matter where you are in the state, and it allows the local context and local juries to apply that based on local values and interests in applying that to a particular court case. That same system is what RFRA is intended to do. RFRA is simply a balancing test that makes sure the compelling governmental interest, which might be weighed different by a jury, or might, in the case of a judge, would be weighed differently by a judge in a community. Is there a compelling governmental interest to implement the government's program or concern? Does that exist? If it's not compelling, then the person's free exercise right is recognized. If it is a compelling interest, then the government gets what it needs to do. But it does it in a way that has the least impact on the person possible. Notable example I would share with you is I'll share two cases with you. One case from Texas. There was a young man, a Native American young man who had long hair, and the local standards of the public schools said that boys can't have hair beyond a certain length. His parents sued and brought a case in court citing Texas' RFRA law. The Texas court looked and said yes. They looked at that, they weighed the two, and said no, there's not a compelling governmental interest to have young men wear short hair. If, in that case, the only rights the parents had was rational basis, the parents would have lost. Because governments would say, you know what, there's a hygiene and uniformity and neatness of look, we could mandate a young man cut his hair. But because there's a state-level Religious Freedom Restoration Act in place in Texas, the compelling interest test showed that this young Native American kindergarten male did not have to cut his hair to go to school. Another case in Florida that really proves out this two-part test. There was a Muslim woman in Florida who was part of a Muslim belief system that, in her case, believed that women should be covered in full face garb with just her eyes showing. Certainly not all Muslims take that stance, but this is the stance that this woman and her family took. And she was going to the Department of Motor Vehicles to get her driver's license made. And in the DMV, she says, you know what, it's my right to not have to remove my face garb to get a driver's license. I don't want to have my picture taken, but I want to leave my full face garb on. The DMV wouldn't issue her license. They denied her license renewal, and she went and sued under the state's RFRA law. What do you think happened? What happened is they applied the compelling governmental interest test, and they applied the least restrictive means possible test. And using the state RFRA law, the state says, yes, there is a compelling governmental interest for you to remove your full face garb for the purposes of taking your photo. But when they applied the least restrictive means possible test, even though there was a compelling governmental interest, they said there's no the least restrictive means possible can accommodate your real concerns, and we're not going to make you take your picture out in public, but you can go into a private room, have your photograph taken by a female photographer, and put on your driver's license and put in your pocketbook, and you can carry on with your business. The compelling governmental interest of having a person's face on their driver's license was fulfilled, but the least restrictive means possible test allowed the woman to have her picture taken in a private room with a female photographer. The test, the balancing test of RFRA works in exactly that way and can be applied to the myriad of circumstances that exist in a state like Florida of 17 million people, or a state like Georgia of nearly 11 million people. The Religious Freedom Restoration Act simply provides that thoughtful balancing test to weigh very difficult circumstances so the government's interests can be preserved and people's religious rights can be maximized to the maximum, can be recognized to the maximum extent possible. Without RFRA, there is no balancing test. The government action wins every time, and essentially, citizens have no constitutional right to free exercise in any action of the government. Every time wins, as long as it's equally applicable to people and they have any rational basis to make it. That's not what constitutional rights are intended to be, and that's why Georgia now needs to act to put legal stability in place, like 34 or 50 other states, to ensure that free exercise of religion is a true constitutional right, and we have those protections not just from federal government agencies, but for state and local government entities as well. With that, I'd be glad to take questions. Yes, sir.
We've heard in the past in this Georgia General Assembly questions about how religious liberty would affect LGBTQ communities. Would this bill help protect faith-based adoption agencies from having to interact or adopt children to gay couples?
Well, you know, if we apply the balancing test, I think what a RFRA balancing test would do would ask the question, is there a compelling governmental interest for any faith-based adoption agency to follow an adoption framework and a placement framework that is counter to their faith? I think as we unpack this, do you believe there would be a compelling governmental interest to do that? It would be up to the state courts to determine, is there a compelling governmental interest to do that? And if they did, would mandating that of faith-based adoption agencies, that they place specifically, even though there's a host of people they could place with, if it would require they place outside of their faith tradition, whether it's Roman Catholic, whether it's Muslim, whether it's Jewish, whether it's a Baptist or secular group, the question is, would there be a compelling governmental interest, and would forcing that interest on the state-based adoption agency be the least restrictive means possible of accomplishing that interest? It's for courts to settle. the RFRA law doesn't prejudge any outcome, but if someone believes there's a compelling governmental interest to do that, then the compelling governmental interest test would be satisfied. If there's no way to accommodate this faith-based adoption agency's concerns by saying, we can only place 50 children per year. We have 75 families per year that we can place that meet our standards. Why couldn't we just place with folks that meet our same faith-based standards and let others place with other in other circumstances? So RFRA in passage doesn't prejudge that. It'd be in the hands of a court, or if it were handed to a jury. But the balancing test of asking the question, is there a compelling governmental interest, is a fair question. I think every single right of free exercise should be subjected to that. And if the compelling governmental interest is recognized, then in that community, in that circumstance, in their context, given the number of children who are available for adoption, given the myriad of possible outcomes, the court would apply that test to decide. So the RFRA doesn't prejudge that.
In some of these states, and I don't know which ones, but some of these states that have religious liberty laws, they also have protections for people based on sexual orientation. Georgia does not have those kind of protections based on sexual orientation. Would that be appropriate to prevent a potential religious liberty law on the state level from potentially discriminating against people?
As you know, we have those at the local level. So, Georgia has seen fit to allow local, with respect to public accommodations, to allow local municipalities and counties to make those determinations for themselves. Georgia has seen fit that one standard should not be imposed across the entire state on that question. Other things do apply across the state. So that's the component that I think is a strength of RFRA. It travels very well. It goes to the standard, this balancing test goes to communities that would elevate the interests of, for example, somebody that is a stated member of the LGBT community, and would weight their interests in their community more heavily than they would in a community that's not adopted that same standard. But in neither circumstance does either side automatically win. RFRA is not an exemption bill any more than a public accommodations law is an exemption bill. It weighs those two interests in a thoughtful way that allows the interest of two entities to come together and sort of be fit in a way that balances. Every single circumstance, even where a compelling governmental interest was recognized to recognize public accommodations, for example, of a person from the LGBT community. In many circumstances, the person's religious right, even if there were a compelling governmental interest that was recognized there, I think those communities would very likely find that. It doesn't mean there shouldn't also be a duty to effectuate this interest of the LGBT person in a way that still minimizes the impact on the person of faith. If you can minimize the impact of the person of faith, why shouldn't you? Without the balancing test, there's no need to do that. That's what RFRA is so strong as. It recognizes very often one side in a conflict sometimes has to get their way. But it still ensures that in doing that, there's a duty to minimize the impact on the person on the sort of the downside of the question, to make sure their interests are still maximized as much as they possibly can be. It's a fit together kind of framework, not a one size wins, the other side loses. And that's very important to understand that.
The communities where local governments haven't adopted those ordinances, what do you say for the LGBT communities in those areas? Any concern that this might encourage discrimination?
Well, I would tell you this. Right now, everything in Georgia just comes down to elected executive power. If they were in a place where a mayor was completely unconcerned with their interests, then they really have no means of redress. The Religious Freedom Restoration Act creates a structure where people of faith apply the same balancing test system that recognizes the finesse that's needed in some of these kinds of questions. I mean, it is intended specifically for some of these very difficult circumstances. With respect to a place that doesn't have a special accommodation law, the presence of RFRA is going to have very little impact there. Because again, RFRA doesn't create a structure where the person of faith that asserts their religious rights wins every time. That's the fallacy of this. This is not an exemption versus an exemption world. It is a fit-together system that balances these interests. And I think it's very important to walk away with that. And that's why we use some for examples. I think you look at what's happened at the federal level. You look at what's happened in other states. You think about during COVID-19. There were states that didn't have RFRA that were able to tell people, you can't open your mouth and sing in your own church. The state of California said that one singer or soloist could sing in a church, but the congregation couldn't sing in church. Could the COVID-19 protection interests of the state be effectuated in a less aggressive means than that? I think it could be. I think if then when you have people of faith in California that said, okay, we can't be in church, we'll go outside. We'll have worship services outside. We'll separate in the exact same way that folks separate in other places, and they were still shut down. Again, is the law equally applicable? If not, then if you're treating people of faith less fairly, with less benefit than folks not of faith, that should be addressed. If there is an equal treatment, but people of faith can't recognize their right to gather and practice their faith, RFRA would say there's a greater interest in people gathering for a religious meeting than gathering for a bowling league or gather for a Little League baseball game. We have a tradition in our nation where religious rights they're enumerated in the Constitution as a fundamental basic right. Doesn't mean that right wins every time, but it's not treated like a flash mob of people who are making a TikTok video, right? A religious gathering is different than a flash mob making a TikTok video. But it doesn't win every time. You have to balance these things, and that's why we're talking about this, that people of faith in California, for example, during COVID, I believe there should have been a way for them to gather. There should have been a way for them to practice their faith. And had there been a RFRA law there, the question would have been, okay, how can the public safety interests of Californians be advanced, but in a way that's the least restrictive means possible on people of faith? And saying you have to stay at home or you have to stand in church and you can't even open your mouth and sing. There could have been a means that would have accommodated them to be able to express their faith in as full way as they could, but it still accomplished that basic compelling interest of a pandemic. I mean, the pandemic circumstance created a compelling governmental interest to keep people safe. No one disputes that. The question was, if there's a RFRA statute in place, there's a duty to make sure people of faith are able to exercise their faith to the maximum extent possible and still effectuate that governmental interest. So that balancing test applies in some practical ways that we saw, I think, very markedly during the COVID pandemic.
I also wonder if in your mind, it's been a few years since we've had the RFRA made. Why this year? Why are you resurrecting this session? Why is this the moment?
I think we're in a place where, you come out of a COVID pandemic. You see there's something as abnormal as a global pandemic. You recognize there are compelling governmental interests to keep people safe. You see that. But when you see governments that aren't subject to RFRA protections for people's free exercise able to be just completely callous to people's interests, when you see a mayor in Mississippi that had a fast food drive-in where people were eating in their cars and getting food in a fast food restaurant, but also then going a couple miles away to a church and saying that you couldn't sit in your car with your windows rolled up with a bunch of cars around you, with your neighbors and your fellow parishioners, seeing a pastor on a stage, listening to him over the radio that said, no, you can't be here, we're shutting you down, you got to go. And we're prepared to arrest people to do that. That's an example of the least restrictive means possible was callously ignored because in the name of a global pandemic. We all recognize a global pandemic represents a compelling governmental interest. But when you have a state-level RFRA Act You have a duty to implement that in the least restrictive means possible, because people of faith exercising their rights do matter. It's not just a flash mob of people making a TikTok video in a train station. It matters. It's enumerated in the Constitution for a reason.
Those court cases you mentioned earlier, I was trying to follow them, but I wasn't sure. Are any of those Georgia court cases?
The Azug Bunam v. Przynski is a Georgia case. It went through.
Promise the spelling.
Yeah, I'll share that with you. That a case originated in Georgia went at. It was actually taken up to the federal courts. You know, when the Attorney General ruled that there is no right to free exercise in Georgia beyond rational basis, there was essentially a complete dead end on the free exercise argument. That the only thread of protection that this young man had was in the federal courts. So they took as a speech case. So the speech case went all the way up. And as we recognize, speech is well protected in Georgia. It's well protected at the federal level. Free exercise is well protected at the federal level. It's just free exercise is not protected at all at the state level. And that's what we found. So I'll share that with you. Bourne v. Flores, that's a nationally recognized case. You can Google that and get that in a matter of seconds. Any other questions? Let me wrap up by saying, our intention in this is to talk substance. People oftentimes in this RFRA discussion will say, well, even people whose organizations have been in the past prompted to oppose RFRA. Many of the principals, many of the attorneys will look at legislators and say, we know this is right. We know there's nothing wrong with RFRA. This is a fair balancing test that applies across our constitutional rights. But the perception of it is such, we just need to oppose this. That's the challenge. When does the General Assembly, or when is the General Assembly informed to advance legislation and create a legal environment that's based on shallow perception over substance? What we want to have is a substantive discussion about this issue. When you think about the substance of the Religious Freedom Restoration Act and how it's not created distorted circumstances at the federal level, it's not created distorted circumstances that shock the conscience in other states, we're wise to do it. I think it's a circumstance where we as the legislators, you can't take on hard issues every year, but every couple of years you do have to recognize it's time we finally put this to rest. The Azug Bunam case was settled in SCOTUS this June on a free speech prong. But seeing the merits of that case win on free speech in the federal courts, and seeing there is zero way that fact pattern, that courageous young man, there was no way for him to have his free exercise rights respected in our state system. You see the contrast, and you recognize we can't ignore this any longer. It's time to finally deal with this issue once and for all in a substantive way, where we see the legal substance of this balancing test that doesn't guarantee outcomes for either side in a question, but that uses this compelling governmental interest test and this least restrictive means possible test that applies across our constitutional rights, not just the First Amendment, but across our rights, and applying that at the state level so folks, for decades to come, in ways that's localized to community standards, as we talked about, the judgment of elected judges, and in a way that accommodates the local ordinances that can create a compelling governmental interest with more weight in one community than another, can settle these issues fairly, but never ignoring the rights of individuals to have anything that government mandates done in the least restrictive means possible, so rights and government interests can fit together in the most effective way. That's what this is about, and it's something we can't wait any longer to make happen. Appreciate your time. Appreciate you being with us. I can share any materials with you that we like. And with that, we stand adjourned.